Ladies and gentlemen, thank you so much for coming to tonight's Wing Hatton lecture, despite the rather distracting news this afternoon. Well, distracting, I mean, just to be neutral. We're very pleased to welcome today our Vice Chancellor, Professor Peter Matthiessen. Yes, and his wife, Dr. Tina Matthiessen, and Professor Mathiessen's mother, Elizabeth Matthiessen. We also welcome this evening one of our guests, Mr. James Badenoch. Take a bow, take a bow. And his wife, Marie. You might have already heard Mr. Badenoch when he spoke on the art of advocacy and on the future of the rule in Bolam, which would be of interest, especially to followers of medical developments and medical law. We also have with us this evening Mr. Justice M. Bawani, sitting next to Mr. James Badenoch. My name is Terry Khan. Welcome to the Wing Hatton Lecture 2016. This is a series of lectures instituted by the two foundations, the Wing Foundation and the Hatton Trust, who are the principal benefactors of the Center for Medical Ethics and Law, of which center I'm one of the two co-directors. The other co-director is Dr. Philip Bay, sitting there at the back. Today, we are making a slight departure from our usual theme of strictly medical legal issues, although we've managed to persuade Dr. Erdos to still keep one foot in the general area. And we have as our chair today, Mr. Azan Marwah. Mr. Marwah is a barrister with the Guild Chambers in Hong Kong, and he's appeared at all levels of court, including the Court of Final Appeal, where he was previously appointed as a judicial assistant. He advises regularly on a wide variety of areas, particularly in family and child law, employment, labor and discrimination law, and in public law. He is also a trained and experienced mediator, having previously acted as a court mediator in civil harassment, landlord and tenant, and commercial contract disputes. The reason why I asked Mr. Marwah to be chair for this session was because he wrote or co-wrote in 2013 in the Hong Kong Law Journal, together with Mr. Justice M. Bawani, an article entitled Personal Data Privacy in the Digital Age. And so I realized immediately there was someone far more knowledgeable than me in this field. So I will leave you to Mr. Marwah's chairmanship this evening and leave him to introduce Dr. Erdos to you. Thank you.
It falls upon me to introduce our speaker for this evening, and may I say, as an American, I'm very thankful for this distraction, something to divert my mind from where it was before. May I first thank the Center for Medical Ethics and Law and the University of Hong Kong, as well as the Wing Foundation and the Hatton Trust for inviting me here today. Some housekeeping matters. Today's lecture is being recorded, and I believe it will be uploaded to YouTube. I have the honor of introducing this evening's speaker, who will deliver the third Wing Hatton Lecture 2016, entitled Data Protection in an Age of User-Generated Publication, Dr. David Eros. Our subject this evening is phenomenally important in this age of social networking and user-generated content. To give this topic some kind of context, all of the top 10 most visited websites in the world make extensive use of user-generated content, such as Google, YouTube, Facebook, Baidu, Amazon, Wikipedia. This is the age of user reviews, wikis, blogs, social media, with tools that give incredible access to virtually everyone in our society, but where the rules of the game are written by some of the largest and most powerful companies in the world. We are therefore fortunate that our speaker is peculiarly well suited to guide us through this topic. Dr. Erdos is University Lecturer in Law and the Open Society Fellow of Trinity Hall in Cambridge. Before joining Cambridge, he spent 6 years at the other university as a research fellow at the Center for Social Legal Studies at the Faculty of Law and Balliol College in Oxford, having received his PhD from Princeton. David's current research explores the nature of data protection, especially as it intersects with the right to privacy, freedom of expression, and freedom of information, and freedom of research. David's Data Protection and the Open Society Project has developed arguments about the nature and substance and operation of law by drawing on rigorous comparative empirical analysis using both qualitative and quantitative methods. I confess that before this evening, I did try to do my best due diligence to research David through the various social networking websites. When he next checks his Facebook, he will find a friend request. Aside from his birthday, which I did discover, and I will say is not today, unfortunately, I discovered that David is actually a very active Twitter user, which, judging from recent news, may suggest that he has a good chance in politics in the future. Without further ado, Dr. David Erdos.
Well, thank you very much, Azan, and it's my very great pleasure to be here in Hong Kong and at Hong Kong University. I'd like to thank the Vice-Chancellor, Ron, Terry, the Wing and Hatton Trust, the Centre for Medical Law and Ethics, the Faculty of Law, and Hong Kong University as a whole for a very, very warm welcome. I was last here as a very young, fresh-faced, I'd like to think, backpacker in the year 2000, and it's very nice to be back here in Hong Kong in rather different circumstances, but I really thank you very much for your very warm, kind and generous welcome tonight. So my theme today is data protection, personal information law, and how that interfaces with user-generated content. And by user-generated content, I mean this massive growth in the publication by members of the general public, by non-commercial, non-professional members of the general public of text, audio, visual material to the world at large. So I'm going to talk about some of the history and some of the logic, both of data protection, then of user-generated content, before trying to bring those two things together and look at some of the tensions, some of the issues, and hopefully speak more generally to some of the challenges which the law faces in this area. So let's start with data protection then. And whatever the results of another populist electoral decision a few weeks or months ago, I suppose, I'm very much a European. I'm coming from a European context. And so I will be speaking from a European perspective, although I think that the issues, in fact, are global and universal ones. And there is another reason to speak from a European perspective. Europe has been described, and I think accurately, as the cradle of the very concept of data protection. And it remains a very strong global champion for this concept. And why is that? Well, I think it's partly because the indirect germs, the indirect origins of data protection have very long and deep roots, particularly in Europe. They go to concepts of the right to personality, to identity, to honor and reputation, which have long adhered, particularly in the civil law tradition in continental Europe. And those concepts were given further impetus by the growth of the human rights movement in reaction to some of the atrocities in World War II. But the direct origins of data protection are much more recent. It wasn't until 1973 that the first Data Protection Act in Sweden was enacted, and the first transnational instrument at the Council of Europe, that's a sort of larger body of European countries, more informal than the European Union, a resolution was passed on this issue at the transnational level. And in theory, in legal terms, each decade since then, we've seen the steady growth and development of data protection. So by the early 1980s, things have moved on from just having a resolution from a transnational body to the framing of a binding convention on data protection, again from the Council of Europe. And by the end of that decade, about half of European countries had legislated a personal information or data protection code. By the 1990s, the European Union had intervened and established a directive requiring all its members to have data protection law and have that according to a common blueprint. And we began to see the spread of data protection outside Europe, including here in Hong Kong as early as 1995. As I calculate it, the third jurisdiction in the world outside Europe to have data protection after Israel and New Zealand. What happened in the 2000s was the decision by the European Union to recognize data protection not just as a statutory code but as a fundamental right, which was entrenched in the EU Charter of Fundamental Rights, given legal status in the Lisbon Treaty in 2009. And this decade was also critical to the global spread, the genuine global spread of data protection. Graham Greenleaf, an Australian privacy scholar, calculated that 70 jurisdictions and territories had data protection law by the end of the 2000s, with I think the majority, certainly the majority outside the European Union, and moving towards the majority outside Europe itself. Another big development in the 2000s and 10s, these are the things which are in a sense coming and spreading, which is that we've moved to a data protection regulation in Europe, where the law will be directly applicable across the entire European space, and the core of that law will simply apply in one form across all those countries. And the global spread of data protection has intensified. Over 100 jurisdictions now have data protection law, getting on for half of the world. So why the 1970s and why this steady development and growth of data protection? Well, there's only one catalyst that really matters, and that is the growth of electronic data processing, which began to get going, I suppose, in a significant way in the 1960s. And, you know, things looked fairly limited in the 1960s. I've got some pictures up from Flickr showing you just how limited they looked even by the early 1970s, I think that is. In fact, it was calculated that there were just a few thousand computers in the country in the United Kingdom in the early 1970s, so about the time European data protection began. But there was something called Gordon Moore's Law, Moore being the founder of Intel, who in 1965 presciently determined that because it was technologically possible to fit more and more integrated circuits on a single silicon chip, the growth of computing power would exponentially increase, doubling of power every 10 years. And although he focused primarily on how that would change information storage, it in fact has resulted in a qualitative shift of power across every element of how we manage and use information, from its collection, through to its organization, through to its dissemination at very small cost, and of course its granular retrieval. And by the early 1970s, the implications of that for rights to identity, rights to personality, rights to honor, rights to reputation of the individual were becoming identified and in Europe with its more regulatory approach than jurisdictions like America, prompting calls for a comprehensive code to protect the individual. And that is what data protection was designed to be. A code requiring an incredibly wide material and purposive scope. So let's just recap what that scope actually is. It depends on the meaning of personal data. Now, data protection doesn't really give the game away in the sense it doesn't tell you what the data is. You might think, gosh, must be terribly narrow and technical. It doesn't even tell you what the protection is meant to be. It might even give you some idea it's all about just physical security of information. Nothing of the sort. Personal data is information, and it's specifically any information which in some sense relates to an identified or identifiable natural person. It doesn't have to be private. It could be incredibly innocuous. Indeed, in the 1980s, when the first Data Protection Act was being enacted in the UK, the name and title of an author's book was given as an example of what would constitute personal data. It has some connection to an individual, has no privacy implication, at least self-evidently, but it is information relating to an identified, in this case, natural person. It was argued it would be covered. And the name of an elected public official, Donald Trump today it seems, would likewise be covered by this extremely expansive definition. And processing, the other key concept in the material scope, isn't something terribly technical. It's anything you do with that information. It could be as limited as simply consulting it. In other words, looking it up and bringing it up on screen. It could be as limited as deciding to delete it. Any operation performed on data, as long as it touches a computer, by default it will be covered. And I don't need to tell you, we're living in a world of ubiquitous computers now, ubiquitous networks and ubiquitous computers. So essentially anything anyone is doing with information that identifies, covered. And that relates to the very broad purposes scope, because it was very much bringing in the kitchen sink, if you like, of issues and concerns which individuals might have with the growth of information power. It wasn't limited to privacy. It was any right or freedom which may be affected. We haven't really decided what might be affected, so we better say anything that might be affected by the growth of computers needs to be regulated by this code. And that sort of kitchen sink approach resulted in a very wide number of duties placed on those who use information in some sense, personal information, or in the nomenclature now we use, who control information. So there are 4 key elements in the European scheme which a data controller needs to consider, starting with some, maybe you might think motherhood and apple pie broad principles, so that you should be fair to the individual whose data or data relating to whom is being processed. You should know why you're doing the processing. You should ensure that the information is relevant, accurate, up to date, it has a quality about it. And you need to specifically legitimize it, either on consent or some other basis. Now that is common across most data protection laws across the world, I would think. Certainly here in Hong Kong, the emphasis on a principle-based approach. But that certainly was never enough, particularly in Europe, to be the sort of clear protection that people thought the law needed to provide. So added to that were rules, and they were really rules around 2 key areas. They were rules around transparency, ensuring that the individual knew that their information was being used, and rights to give them then control, some element of control over what other people were up to. So this starts with the controller having to go out ordinarily and tell the identified individual what, in rough terms, is going on with data relating to them. And that's pretty much an absolute duty if the data is being collected from the individual. It has certain limitations if the information is coming from the public domain or from another individual. But the individual by default also has a right to demand the full set of data virtually, to say, okay, well, you've told me roughly what's going on, but that's not enough for me. I want to know exactly what you're doing, exactly what data you're holding. And that relates to rights to object to the use of the information, of which there are a number: the right to erase illegally processed data, the right to rectify data which is inaccurate, the right to complete data which is judged to be incomplete, and the right to object on one's own grounds related to one's own particular position about the data. You know, you might have a particular need to remain anonymous, and if you bring that to the data controller's attention, they need to take that into account. Another set of rules which is very important in a health context are the rules regarding whole categories of data, which the legislator has deemed sensitive, special categories of data. And preeminent amongst these, alongside sex life, is health data. But there are many other categories: criminal data, racial origin, political opinion, religious belief. And here the tables turn from being a presumption that if you are a good data handler, a good data controller, your activity will be legal, to saying that unless you have a waiver from the data subject, the individual whom you're processing about, the processing is illegal, because you need essentially the consent of the individual or a waiver from the individual to process sensitive data. And related to that, then, these three elements, which add up to quite an expansive substance, are disciplining rules of security, data management, and really tough rules on transferring information to jurisdictions which don't have these kind of provisions, which is still at least half of the world, if not more. And enforcement not just by the courts, which is what we're all used to, but enforcement by a regulator with substantial powers of intervention. And that has a European element in the EU scheme, because they cooperate through something called the Working Party of Data Protection Authorities. And you can see that this in some ways seems a bit of a world away from the nature of the internet as we know it. I mean, the nature of the internet as we know it seems to be an almost unparalleled example of information anarchy sometimes in terms of the use of information, and yet this legislative scheme seems to be quite the opposite of that, saying a huge amount of this information needs to be tightly controlled, subject to very severe rules, and subject to very clear discipline. Are there any limits in this scheme? Well, the material scope, I would have to say, has been drawn up really as expansively as possible, or apart from possibly on the identifiability aspect. So there are very few limits there. The general substance, the principles have a flexibility about them, but many of the rules do not. And so the European legislator did acknowledge that there needed to be some derogations and exemptions as well. So what I'm setting out is the default, the general provisions that apply, but derogations or exemptions to establish some kind of equilibrium with other rights, other interests, which can be in extreme conflict, notably freedom of expression, but there are others, with this kind of tight control. I'll come back to that, but before I do, I want to introduce this other phenomenon we're going to be talking about this evening, which is user-generated content. So user-generated content then, how did this develop? How did this grow? Well, user-generated content is obviously an online phenomena, and it's therefore interesting, I think, to go back to the very beginning of public for the general public online networks, which again began as early as the late 1970s, early 1980s. And the great difference between this form of communication and earlier forms, like broadcasting, or even earlier, like the press, was that this was a two-way technology, obviously. You know, the user could write back. But it wasn't really thought that that would result in information flowing in terms of publication in a two-way way. In fact, Sam Fadida, who developed this early technology actually in the UK, said that view data, it was actually called view data, was designed for the dissemination of information. Yes, users would be able to call up very specifically what they were after. That was the two-way aspect. But the actual information which was sitting in the data banks and being retrieved by users would remain centralized, and it would remain large controllers who were agglomerating the information right from its origin to its end use. However, the successful general public information systems, even in the 1980s, were seen to rest not so much on that top-down notion of information, but on the ability these new technologies offered for user communication. So Marie Marchand, writing on the French Minitel system, which is to the right of the slide, there's a little representation of it, found in the late 1980s that yes, Minitel was offering information, and it was also offering games, which has some historic interest in terms of the development of this technology. But above all, what it was offering users and what was really driving the growth of this product to millions of terminals in France by the 1980s was that it offered a forum where ordinary individuals could make themselves heard to the world at large. And we saw similar things with America Online and the steady, largely unnoticed but still steady growth of these bulletin board systems like America Online in America in the 1980s as well, again resting on user communication as much as top-down information. And looking to the development of Web 2.0, fast forwarding, that stress on user communication has gathered pace. Most content now on the internet is, in a sense, user-generated. This isn't some sort of minor phenomenon that data protection and personal information needs to confront. This is the majority of online publication. So what did data protection authorities, what did the law actually do about these developments? Well, it can't be said that they ignored it, in fact. Even by the early 1980s, which I tracked down some examples of, in fact, what these systems looked like in the early 1980s from the Centre for Computing History in Cambridge. And you can see they were fairly rudimentary. They were largely text-based because of bandwidth issues. But, you know, in terms of the time, they offered something entirely new. And they were correctly identified as a severe threat to privacy by the International Conference of Data Protection Commissioners, which, by the way, is coming to Hong Kong next year, remains a very important body in the privacy policy and legal sphere, who in 1983 issued a declaration on new media, identifying that the key difference here was that at very small cost, information could be widely disseminated across the globe, and that this was happening not just with suppliers of data, I mean in terms of service providers providing that kind of information, but subscribers themselves were publishing large amounts of data, including sensitive data, health, sex life, this sort of thing. And that posed a danger to personal rights, and it also posed a problem with the conflict of laws, because service providers could set up in another jurisdiction, could suck in user-generated content, could push out user-generated content sitting offshore, if you like, and national provisions which have been established in countries in Europe to do with data protection law could be circumvented. I mean, it's very prescient stuff, but as early as 1983, this was being talked about and identified. To be fair, the issue then, in policy circles and legal circles, largely died. And I think it largely died because the technology was not actually able to attract the users in the numbers which were expected at that time. Maybe because, in fact, user communication wasn't developed as much as it should have been. In a few countries, France and the Minitel, 5 million users by the end of the 1980s, yes, it was a national issue. America, largely rejecting regulation, yes, it was steadily developing. But in most European countries, including in the UK with press television, press-tel systems, they really didn't develop. Less than 100,000 users. They really didn't develop, so the issue died. But it re-emerged with a vengeance in the late 1990s with, of course, the development of the World Wide Web and the genuine growth of the Internet. And, of course, that coincided with the directive, the EU directive, compulsory blueprint for all European countries coming on stream. And so the issues re-arose and re-emerged in the European Court of Justice in what remains a pretty seminal case involving a single natural person who had published information to a sort of primitive blog-type system called Bodil Lindqvist in Sweden. And what Mrs. Lindqvist had done is she had been sent on a web course by her relatives as a nice present in terms of this new technology coming along. And she had a great time. She developed a blog which mentions some other people who are volunteers with her in her church. But she mentions some details about them, hobbies, telephone coordinates, jobs, and in one case that they had a leg injury and were therefore in half-time at work. And she found herself, I mean, the people did not like the fact that their information was being disseminated. She actually removed the information, and this sounds quaint in terms of user-generated content today. She removed it instantly. She took it down as soon as she realized it was causing offense, but she nevertheless found herself prosecuted under data protection law. And the issue went to court, and it went all the way up to the Court of Justice, which finally heard the case in 2003. Was Bodil Lindqvist covered by this developing code? Well, she argued, of course not. This code was designed for big databases where corporations and organizations were organizing in a standardized format details about people. It wasn't designed to cover an unstructured web page or blog type system. And in any case, wasn't there an exemption in the law for purely personal or household purposes? Well, the court said, no, but this law is designed to protect privacy and anything which might be implicated by networks and computers. We cannot exempt you from the data protection code. And in particular, that once you're publishing to an indefinite number of people, that cannot be considered purely personal or purely household. It's moved outside of that, and it's moved into precisely what the law needs to cover. In fact, they said it was clearly not the case that these sorts of exemptions could be envisaged to cover this kind of activity. Well, seeing as I'm talking to the Centre for Health Law, what did they say about the sensitive health issue? Well, equally, they took a very broad interpretation. I think the argument generally from Mrs. Lindqvist was that health data was really about medical practitioners or people who were, going out to, in a structured way, record medical history. The court took a very different approach and said, given the fact the law is designed to protect people, all aspects, physical, mental, anything to do with the health of an individual needs to be covered by this sensitive data definition. Mrs. Lindqvist also argued that if this was the case, the entire scheme was simply an affront to the free flow of information and ideas, the right to receive and impart information, and it should simply be struck down on that basis. The European Commission tried to use this other derogation, which is more permissive for journalists essentially, but also covering artistic and literary work. And the Commission rejected both of those, the court rejected both of those arguments, but did say that there needed to be a balance here. That although the general provisions applied, they did acknowledge that freedom of expression was affected, and also they said that freedom of religion might be affected because it related to Mrs. Lindquist's church activities. And it was up to courts and data protection authorities to interpret all of these provisions I've been talking about in a way which didn't unduly impact on these other rights. But that's quite a challenge, given how rule-based a lot of the regime is. Yes, they found that Mrs. Lindquist hadn't been, for very unclear reasons, responsible for an illegal international transfer of data by placing information on the web. But, other issues, like she clearly had processed sensitive personal data, clearly without consent. What is the court meant to do? Is it meant to just erase whole aspects of the statute? Or is it meant to only interpret when it's possible to interpret rather than rewriting legislation? This remains a major headache in European law. But there were lots of other unanswered questions. How practicable is it to try and enforce the rigors of data protection law by targeting single individuals? We're now talking about hundreds of millions of single individuals across Europe who, in a sense, could be caught by these kind of stipulations. How can data protection authorities, who may only have a couple of £1 million a year budget, be expected to police on that kind of basis? What about the responsibilities of the service providers, which going back to 1983 were flagged up for consideration? Okay, Mrs. Lindquist really wasn't using an active service provider, which was helping to structure the content and encourage the content and push it out to users. But we know with the development of particularly social networking sites and discussion forums, that's precisely what service providers in many ways are doing. What are their responsibilities? And another thing which was left unanswered is the Lindquist case focused entirely on protecting third-party rights, i.e. not Mrs. Lindquist's rights. I mean, she was very much not being protected by this criminal prosecution, but the rights of others, third parties who were mentioned. Yes, a very important issue, but what about protecting users and their information in this new context and making sure that they aren't making choices about their own information, if you like, which haven't been properly thought through? And I think it would be fair to say that particularly with the development of social networking sites in the late 2000s in a dramatic fashion to near ubiquity itself, attention shifted amongst regulators towards looking at the responsibilities of service providers in this area. Not that they've entirely given up the idea that the individual may be caught, by the way. Now, we could look at that in terms of the EU regulators as a whole issuing an opinion on the responsibilities of social networking sites in 2009. But given that I'm talking to a health audience, at least in part, I thought it would be more interesting to focus on some specific guidance for health discussion sites, which was drawn up by the Italians, the Italian Data Protection Authority, in 2012. Really focusing on what they called site managers needed to do in a data protection context when dealing with health data. And they started, and it was a formal decision which was passed by the Italian DPA and published in the Official Gazette in Italy. I think you can see at the beginning that it sort of talked in Lindquist terms about this need for balance. These discussion boards, which again have a significant history from as early as the 1980s, but have definitely grown and developed, have benefits. They increase understanding and knowledge, particularly for users, about health concerns, and they provide a forum for the mutual support of people facing quite often very significant difficulties. They are in general a good thing. But the publication of health data and what could amount to quite stigmatic data permanently, potentially, on the internet poses very clear risks. So what should someone who is setting up such a service be doing to safeguard against those risks? Well, the guidance focused largely not on this third-party issue, it was mentioned, but on ensuring that users who are uploading their own information, if you like, did so only on the basis of a very good consent. So that meant that the site manager had to flag up the possibility that they could publish only pseudonymously, not using their real name. That they needed to say what sort of publication to the world at large was envisaged. Was it just to registered users? Was it going to be available to search engines? And to warn individuals about the risks. The risks of uploading, say, an image which in fact identified them, or some other data which identified them. And yes, to be especially careful about identifying third parties in the data, perhaps indirectly or inadvertently, about another family member or another acquaintance who is suffering similar difficulties. And also to facilitate and mention those empowerment rights, the rights subsequently to update the information, to rectify the information, to object to the information. I mean, there are lots of difficulties here in the sense that there is a need for a balance. I mean, if someone wants to delete data in relation to a conversation, where do the other users who are part of that conversation, where does the user who wants to look at that discussion as a future resource, what are their rights? I don't think that the opinion really clarified these matters, but it did flag up that there were these empowerment rights which remained in play indefinitely. But certainly one aspect which was stressed very strongly was this fully informed, freely given, specific, express consent of users for the publication of highly sensitive information relating to themselves. And you might think, well, very good. You know, that's at least one thing we can all agree on and is very simple. But technology is always challenging us. And a technology has come along which even makes that element very, very difficult. And I'm thinking here of the growth of the Internet of Things and how that interfaces with user-generated content. So particularly over the last 10 years or so, with the growth of notions of the quantified self, we've seen the rise of systematic recording by devices of health information specifically, but fitness information, sleep pattern information. And yes, individuals do express an interest in socially publishing that. Perhaps that relates to an interest in life logging and sharing of that life logging experience. Perhaps it relates also to sharing understanding and knowledge. So it has a self-expressive aspect, and it also has a health, knowledge and understanding aspect as well. But it carries, again, very significant data protection risks, which were addressed by EU regulators in 2014, saying that people who develop applications which allow users to plug themselves into these devices and publish to their circle or beyond need to ensure that users are able to review, edit and decide on any information prior to publication. And that unless they specifically opt in, that should not be indexed by search engines. How does that relate to, I mean, I think that's very sensible advice, but the developer of a product might say, the whole idea I want to give to the user is a seamless and ubiquitous experience of a device. And I don't want to bother the user with all these opt-out boxes, opt-in boxes, large consent on each granular aspect of things to be published. That isn't what I think my product needs or the user actually wants. But the dangers of not doing this kind of thing were very painfully came to light with the Fitbit scandal. I don't know how many of you know about the Fitbit scandal, but it was a fairly significant, for the individuals concerned, scandal some 5 years ago now. In a sense, users of this Fitbit had given their consent. It was user-generated content. They had decided to publish their data to the world about how they were getting on with their fitness schedule. What they probably didn't realize, although I'm sure it was there in the terms and conditions somewhere, was that the computer was going to make various deductions as to what sort of physical activity, for how long, and how vigorous that activity was. And it involved two categories, not one, of sensitive personal data, and it was the two big ones, health data, but also sex life data. Worse yet, Fitbit had offered only an opt-out from this information being automatically made available to search engines for ready indexing against user identifiers. And I've actually erased the user identifiers on this slide, which I thought in the circumstances might be appropriate. Well, as I say, this came to light, and funnily enough, Fitbit very quickly changed their practices, changed their policies. No longer was information going to be automatically indexed to search engines, and they may have made other changes as well. But the horse had bolted, so to speak, and I think this does show the dangers of the product life cycle, the relentless market pressure to simply introduce products and maybe think afterwards what the privacy implications are. And the law is there really to say, no, you need to think about privacy, data protection by design and by default prior to the release and during the development stage of these new products. But I want to close by looking at a sort of related legal issue, which is that both in relation to the discussion boards and in relation to the Internet of Things, one issue, one elephant in the room has been the search engine. And I think probably all of you are probably, or most of you are probably aware that there has been a rather significant decision from the Court of Justice on search engines recently. So what about all of this kind of thing? Well, data protection concern about the retrievability and searchability even of public domain content, in fact, also has a long history. It goes back to the very early days of data protection, at least to the early 1980s. And, you know, we started with things as primitive as tree structure indexes, and we moved on to keyword searching, and we moved on to full text retrieval, and we moved on to more and more sources being included in these indexes as well. And you might think, well, the rise of the general search engine, which I certainly remember as a young undergraduate using in Oxford in the 1990s, you might think, well, surely if there had been this discussion and debate about much more primitive forms of search, even as the early 1980s, that would have been the time to intervene with search engines right when they began. Data protection by design, data protection by default. Not really. For many years, despite the growth of the general search engine by the mid-1990s, clearly being a game changer in terms of the threats, which, yes, search engines have many benefits, but they find the needle in a haystack, maybe related to a very stigmatic aspect of an individual, and they actually agglomerate the various needles in the haystack to provide a structured overview related to that potentially stigmatic thing. You might think that they would have been tackled right from the beginning. But they were seen as largely off-limits for at least European data protection due to a number of factors. I think preeminently because they were based in the United States, which has famously rejected anything like the data protection codes I'm talking about tonight, and the jurisdictional problems of seeking to go after these entities which were essentially based overseas, going back to the 1983 resolution on the dangers that these things could cause to national law, was seen as too great for any regulator really to take on. They had also developed this idea that all these service providers I'm talking about, or most of them, weren't active in the sense of having active responsibilities, but in fact were conduits between the original uploader of the information and the end user. They should be treated as neutral intermediaries and should be off limits largely to direct regulation. And yes, quite rightly, they were freedom of expression concerns about regulating search engines, and the way in which freedom of expression, the right to receive and impart information, is conceptualized even in Europe remains very diverse. And the sheer impracticality of treating search engines as data controllers was also very, very clear. It would imply that search engines should be sifting through every element of content before they are processing it, actually. How they could do this, I don't know. But before they are processing it, to make sure that it was accurate, to make sure that it was relevant, to not process data without consent if it was sensitive data, etc., etc. I mean, this would not be possible. Search engines could not operate if they were treated as full data controllers. A myriad of these issues actually remains, despite the court ruling from the Court of Justice in 2014. Essentially, the Court of Justice parked all those difficult issues and said, well, we only want to focus on what happens when someone, after the event of processing, complains about the information in relation only to a name search. We don't want to deal with the fact that, of course, search engines are processing the information and might bring it up in the 100th page in relation to, what a newspaper may have published on a particular day of the month. We don't want to deal with their responsibilities there. We don't want to deal with their proactive responsibilities potentially as a controller only after an objection. And luckily enough, what we've been asked to consider isn't a sensitive data category, so we won't deal with what might be the case if it's in these rather stricter categories. The issue actually involved the publication in a newspaper of details of a public auction relating to bankruptcy information for social security debts of an individual, a Mr. Kosea. So it wasn't user-generated content. But the decision has been used to place some privacy limits, some limits to the damage to reputation and other interests on user-generated content. The biggest number of users in terms of getting information redacted or erased to some extent from Google in particular as a result of this ruling has actually been Facebook. And I think it would be fair to say that must relate in large part to user-generated content. So what did the ruling actually say? Well, it had three key elements to it in terms of general principles. And in fact, I would say as someone who studied data protection, they weren't that new. They were what data protection regulators had been saying for decades and saying in all sorts of international and European and national resolutions for decades. But what made it significant was this wasn't data protection authorities saying this. This was Europe's top court. And it wasn't Europe's top court saying this in relation to an individual based in Sweden, Bodil Lindqvist. It was the court saying it in relation to the Internet's most powerful actor, namely Google Inc. So of course Google tried to say freedom of expression would be imperiled and we are essentially a neutral intermediary. And the court wouldn't really have it. They didn't even acknowledge that freedom of expression was implicated by their ruling. And they said that the processing of data by a search engine in terms of making it available and organizing it and structuring it and then establishing the ability to search and integrate that data was additional and distinguishable from the initial publication, which, as I say, will often be by a user, an ordinary member of the public. intermediaries, if you like, can't simply say we're some kind of conduit. They have to look at what they're doing themselves to data. So they are covered by the law, at least in part. And the law itself was interpreted very protectively of the individual, at least in the context at which it was looked. So they went as far as saying that an individual who is mentioned in this data in relation to a name search, simply by requesting that data to be removed, has a right which overrides as a rule any other interest which is present in that processing. And they pointedly described what was present on the other side as an interest, not as a right. Not as a right to freely receive and impart information, but in Google's case, in the search engine's case, merely an economic interest, and even in the public's case of finding information, merely as an interest of finding information relating to a user by reference to their name. That certainly surprised me, even as a data protection lawyer, this emphasis on rights on the one hand, but only interests on the other. And that relates, I think, strongly to the fact that data protection itself is now a fundamental right in Europe. That we've moved from seeing data protection as only the interest and other things as rights, to increasingly seeing data protection. I mean, one scholar has described the court's jurisprudence as elevating data protection to a super right. And it is true that I think the only right which is specifically entrenched in the EU treaties themselves, as opposed to simply in the EU Charter, is the right to the protection of personal data, which I think shows you just how seriously and strongly some parts of Europe take this protective scheme. Which really brings me to some final thoughts and my final slide. European data protection in many ways is a very, very noble idea. It champions very important values relating to the dignity and privacy of the individual, values which are very strongly at risk by socio-technological change. But it does so in a very extreme way in terms of what it tries to cover and the number of duties which it seeks by default to impose. And it doesn't do a very good job, frankly, at then reconciling that to other rights, right to health, right to freedom of expression, other interests which are implicated. And it struggles, frankly, with then enforcing those strictures on an increasingly anarchic, in a way, information environment. European data protection is noble, but at 40 years old, I suppose, since just over Sweden's first law, not in very good health. And this interface with user-generated content and its subsequent development and processing by service providers themselves epitomizes many of data protection's, European data protection's challenges. So where do we go from here? Well, I think what we need is a framework which is legal, which is contextual, which is protective, and which is genuinely effective. Well, the European law offers us a legal framework which is in theory very protective, but is frankly not very effective. And the Facebooks, the Googles, the internet offers us a reality which is very contextual. It does differ very substantially in terms of what context people are using information online, but the way that then interfaces with privacy and integrity is unbalanced. And it's unbalanced because it offers insufficient real protection to the very real individual interests and rights which are affected by this new technology. The scale of the challenge of trying to bring those good things together to offer something which really is legal, really is contextual, really is protective, and really is effective are enormous. And I'm reminded of what Professor Spiros Samitis, who was one of the founders of European data protection, said as far back as 1997 at another international data protection conference in Montreal, which is that data protection is an impossible task. And I think looking at that, 20 years on, at least, or essentially 20 years on, that task has certainly not become any easier. In fact, it's become an order of magnitude more difficult. Europe, frankly, doesn't have all the answers, but it does have substantial experience of trying to regulate some of these issues by law. But I think we also have an awful lot to learn, and that includes learning from you in this wonderful city of Hong Kong. So thank you very much.
Thank you, David, for what was a very brilliant and fascinating lecture. A few housekeeping matters. David has kindly agreed to answer questions from the audience. Before asking a question, I'd ask that you please state your name and your affiliation, and try to limit yourselves to one question rather than making a speech. If somebody doesn't raise their hand, I will exercise the chair's privilege. Oh, yes, please. Perhaps you can wait a moment for the microphone.
Yeah, John Bacon-Schoen from Hong Kong U. I'd just like to ask you about the Google Spain decision that you referred to, because I found that a very interesting decision. I can understand that it's a very fuzzy decision in some ways, but I thought it's interesting because it was the first attempt I'd seen for someone to seriously look at rehabilitation. Now, I hate the fact that this is being characterized the right to be forgotten, because I don't think that's what this is about. It's about the right to be rehabilitated. And in the internet era, I must confess, I'm not sure whether it is possible to be rehabilitated. So I thought it was interesting that they were attempting to say, yes, we need to protect the right to publish, but we also need to have some possibility of rehabilitation. Now, there are many things we may say that the judgment is fuzzy, but I'd be interested to see whether you think that this is a feasible attempt, at least a first attempt, to try and deal with rehabilitation.
Yeah. Well, it's not the earliest attempt. To be fair, there were even attempts in the 1980s to regulate press archives by, I think, some Scandinavian countries at the time said after 7 years, sensitive personal data should be deleted from any public computer archive, including things like criminal data. So in some ways, it's back to the future stuff in the sense, if you look enough into what data protection has said in the past, it's had even more extreme things to say in the past, and the technology has moved on and frankly has swamped data protection, which has happened again and again, frankly. But that's sort of me putting on my social science hat rather than my normative hat. I think that the idea of the granularity of processing and looking at in the particular context how much of an impact, a negative impact, an unjustified impact are you potentially having on an individual, as against what benefit is your processing bringing to yourself and your rights, but other people's rights and interests as well, is the structure of data protection, and it is what I suppose in broad terms is needed in a digital age. So I'm not opposed to the idea that we need to all be responsible in a digital age in terms of our activity, and if Google in its search engine isn't going to be responsible, then we might as well all go home, because it's so powerful, and if that's not going to be regulated, then why should we be regulating the news agents or or whatever else as a data controller? So I'm not unsympathetic to the idea of trying, whereas as a lawyer I am very unsympathetic, is the fact that the legislative scheme is not fit for purpose. The law doesn't say that it only applies in this particular circumstance on a name search after the event, and only when in the public interest it's determined that it's right to go ahead with a redaction as opposed to allowing it to stay up and be indexed. The statutory law doesn't have any of that kind of content, particularly around sensitive personal data. And yes, you can say, well, from the machinery comes some other considerations. The court didn't tell us actually what the other considerations were because they wouldn't even acknowledge freedom of expression was engaged. I would say freedom of expression is strongly engaged. And yes, of course, you can bring in other constitutional rights, issues to do with proportionality. But it's worrying that in Europe we are now going to have a law which threatens companies with, and organisations and even individuals with fines of up to 20 million euro or even 4% of global turnover, with laws which do not provide the sort of legal certainty for other rights and other interests that we need and deserve in a liberal democracy. And I think that it runs the risk of bringing the entire stat code into disrepute, because we should be worrying and thinking about establishing law which is clear and precise and properly balanced. That's our work to do as information lawyers, and simply to have a law on the statute book which says one thing, but the reality you should expect is something quite different, is not good law.
Thank you, David. Any, please. Up here in the front.
Ron Zeman. Can you say something about the need for data sharing? And I know the Global Alliance for Genomic Health has been really pushing the idea that putting privacy and confidentiality at the heart of this is probably not the right way to go if we want to benefit the health of mankind over the next 10 or 20 years. And that, as Bartonopoulos has pointed out, under one of the previous earlier conventions, one has the right to benefit from a science of which, you know, big data is one such right. So this seems to fall into what you were saying, that there has to be proportional balance between one right and the other. So what do you feel about the Global Alliance's push towards making this right to benefit from data sharing a matter that should be taken into account?
Well, Ron, you are asking me a difficult question in the sense that I will have to say I don't know enough about the precise details of and I of course listened to Bartha's lecture and I have some understanding of what's being called for, but I don't have enough of an understanding of the precise details of the data sharing to comment precisely. I mean, yes, information technology brings many benefits, and inhering in the use of information technology, what I would emphasize is that many other rights, not just interests, but rights are engaged. The right to benefit from health, both on one's own account, but also in terms of contributing to scientific knowledge and understanding, would be one clear example, which I'm sure is felt very keenly in this room, but there are many other rights. You name it, there is quite often a tension between data protection and those other rights. And we can't all be Luddites and run away, or indeed create law which, if in fact was honestly applied, would make many of these positive technologies simply illegal to operate. That is not a sensible way to go. But I would say that thinking about the safeguards is a sensible way to go. And I suppose I do feel with the health information and the publication of large amounts of ordinary members of the public health information, even with their consent, we potentially have to think very carefully in designing that service. Is it really necessary for someone to be fully identified? If it's not, then what about identifiability, particularly with biomarkers and DNA and other things? And are there steps we can take without significantly compromising the integrity of the data to protect people from potentially significant risks which aren't very well conceived because they are potentially in the long term? And the difficulty we have is that once information is on the internet and is flowing, it flows everywhere. And it flows to jurisdictions going right back to the 1983 resolutions, which don't have any protective scheme at all, really. And that's the rub, you know. Where do you... okay, individuals do have a right to make their own decisions, but I think in establishing services we do need to think, and products, we do need to think on our own account, are we behaving in an ethical and responsible way? And yes, share, but do think about the necessity of identifiability or identification. If it's not really necessary, maybe make it, at least by default, not there.
Well, I have a question, leading on from what Ron had asked. In the United States, which, as you discussed, has been relatively less well-regulated when it comes to personal data privacy, there's been a huge amount of innovation, particularly in medical technology. At the same time, you don't have the same health insurance or health systems that you have in Europe. One way that they're dealing with that lack of coverage in the United States is to provide remote healthcare, or crowdsourced healthcare, or even using user-generated content to provide assistance over the internet, sometimes using the Internet of Things, but at the same time seeking consent from the data subject. In that kind of context, the consent from the data subject is not coerced, but it's so extreme because they don't have necessarily too much choice. They can either have very free, high-quality healthcare where they don't have an alternative, or they can have nothing. Mm. And at the same time, they may or may not read the terms and conditions, but even if they do, in order to provide that low-cost healthcare, sometimes, or free healthcare, they have to give away their rights to personal data. Mm. Yeah. There's that tension.
There is indeed.
Yeah.
Well, I mean, obviously, from a European standpoint, that kind of product would be extremely legally problematic because we are talking about health data. As I've said, the definition of consent requires the consent to be freely given, not as a take it or leave it, but freely given, specific, informed, and rescindable. You know, these are very, very, very strong standards. And above that, I always emphasize to my students, actually, that data protection has an autonomous aspect in terms of, in a strange autonomous way, actually, because it says that you can't rescind your rights. I mean, you can't, it's not a once-off autonomy. But it also has a paternalistic aspect, which is that as the creator of a product, you need to act responsibly irrespective of whether you're getting someone's consent. And you know, if you're engaged in excessive data processing and onward transfer, which is excessive, and not, you know, then you, at least the European framework has said you can't be doing that irrespective of whether you've got the individual's consent or not. Of course, you can say on the flip side that it's precisely these kind of standards that make companies, and I think when the penalties get much more serious, as they will under the new regulation, potentially increasingly say, well, we'd rather not develop our products in Europe. We'll go off to America and develop our products where they aren't these kind of restraints. And that brings, you know, very UK perspective on data protection back to the idea of, well, we need an effective balance here. And I can't say that America has an effective balance. The theory of the law in Europe is not an effective balance either. And somehow we've got to come together and try and create this kind of well-proportioned, properly enforced balance. But it is a real challenge when you have different regions of the world which have become very entrenched in their own camp. And you know, the US at very much one pole and Europe, which is odd because in some ways you might think, you know, on many other issues, of course, Europe and America are very close together, but on this issue, certainly not.
The way that you frame it, and I totally agree with you, but both in the context of this Pandora's box treatment of information on the internet, but then on the other hand, the flight of innovation and industry to places where they will be less regulated. Is Europe, and particularly from a Hong Kong perspective, do these small jurisdictions, do they have that kind of choice? Can they either invite innovation and industry, or can they regulate their data privacy? I realize you really abusing my privilege here, Chair.
I think if you're talking about, I mean, a well-proportioned regime which offers that balance, then you can make the argument that this should increase trust, and that actually could be positive for economic development. Of course, there is a danger that in small jurisdictions that's a more difficult argument to run. But you know, legal uncertainty and impractical law, particularly when it actually begins to be enforced, might be the real threat here. And a sort of well-balanced, well-proportioned law might not be so scary to companies, at least the companies you want to actually attract. Maybe there are some companies and some practices you don't want to attract.
Yes, down here in the front.
I'm Mark Phillips from McGill University. I wonder if you can elaborate a bit more on the idea of how certainty can be achieved for anyone who's subject to the law, including large companies or individuals, because I mean, obviously that seems like an important goal that the law always tries to achieve, but there seems to be some difficulties, both in the sense of if we're going to move towards constitutional balancing of different rights, if we're going to move towards notions like the public interest, it's very hard to have certainty in that kind of context. And as additionally, even if we end up with more rules-based approach, that's even a very good rules-based approach, the technology is moving so quickly that it's difficult for them to last very long. I'm thinking, for example, of, I mean, there might be disagreements about it, but in the U.S., the HIPAA privacy rule, de-identification rule names, 17 or 18 explicit fields that have to be removed, which probably made good sense at the time it came out, but over time don't seem to fit with the reality anymore. So I'm wondering if you can speak to kind of the rules, principles distinction.
I mean,
Thank you.
I'm not coming here, as I said, with all the answers. There is a problem between a more principle-based approach and a rules. Rules are all well and good if they actually work and make sense, and it does produce that sort of element of certainty. I'd have to say the thing which bothers me most about the European scheme isn't so much its lack of detailed specificity, which a principle-based regime would never give you anyway. It's the fact that it has so many detailed rules which cannot be implemented, which, if actually taken seriously and applied, would simply shut down technologies which we all use and we don't expect to be shut down. For example, search engines. And we should care enough not to be passing these statutes like sensitive personal data bans or very odd provisions on unclear provisions, more unclear, but around international data transfer, which cannot be effectively applied. We should be thinking, okay, if we can't have a rule here, actually let's abandon the rule. Let's just have a principle and say, actually, the best we can say is try and be transparent. I mean, do be transparent, and if you're really obviously not transparent, we will take action against you and you'll get the development of a case law. If we can develop rules, then let's make the rules proper. And that will require a lot more detail, frankly. I mean, it's not enough to have a sensitive personal data ban and then a few odd caveats as to when it doesn't apply. No, I mean, if you are going to go down that route, it's going to be a vast code, with all sorts, and it's going to have to be re-looked at the whole time. I mean, one of the problems we have is that in a European context, is that the default gets put in at European level, and often is not quite a throwaway, but member states try and sort out any issue that causes. And no one feels terribly responsible to actually work out, well, actually the court's just said search engines are data controllers. What does that mean we need to do in terms of making the law actually sensible in this area? It's no one's responsibility. No one's taking ownership of that. And we see this across issue area. I would be, with effective enforcement, it could be that a more principle-based regime would work, but we can't know really unless we have effective enforcement. Of course, rules are good, but only if they can make sense, and a lot of the rules don't make sense.
Please.
Thanks, Peter Matheson from the University of Hong Kong. Whilst you were talking, I was really struck by a parallel with a previous Wing-Hatton lecturer who was talking about prenatal diagnosis and made the point that the technologies have outstripped the regulation and that currently there's a lot more brain power being applied to development of new technologies than there is being applied to the regulation that's in parallel with it. And so that leads me to a question based on your last answer. Is there any prospect of sort of international consensus, a sort of Paris Accord like climate change? Is there going to be an international consensus on data protection? Because if there's not, then I think Professor Spyrios was right, and actually maybe people should be devoting their brain power to some other aspect of regulation.
Right. Oh, okay. Well, we've been trying and debating for at least 30 years, maybe longer. In fact, I think right back to 40 years, the idea of an international convention and the chasm in terms of understanding, which is still there, to some extent has possibly grown, remains. You know, that there have been attempts. I mean, the International Data Protection Commissioners, I think, drew up in Madrid a number of years ago now, you know, a blueprint for laws across the world. The Data Protection Convention is officially open to signature and ratification by any country of the world, and they are now a smattering of countries outside Europe which have signed, Uruguay, I think, and Mauritius. But, you know, this is not going to change reality, frankly, unless something very dramatically shifts. No, I mean, there is, and it produces a huge conflict of law problem in the sense that, no, there is no sign that we're going to move anytime soon to sort of a universal system. It is true that over half the, you know, about half the world now has some kind of data protection laws. So the concept is spreading. There's still a lot of variation. I mean, it would be an interesting empirical project actually to work out how much variation and in what way, but there is still significant variation between even those 100 jurisdictions. But it was something like 12 in the 1980s, and it's gone to, you know, over 100. So I think the issues are too important and too pressing to say, well, we'll just walk away and we'll go and do something else. And this is obviously something where the law cannot afford to simply not be engaged. The threats to the individual are too extreme to simply the law to walk away. Maybe that's part of the problem, that then you have an awful legal mess, or to some extent almost inevitably. But I mean, I think that there is the potential for more consensus than we've seen. But I think that the difficulty, I mean, as I see the European process as it's worked out, is that you had very poor implementation of what was on the books, and regulators which really weren't particularly equipped to properly enforce. I mean, some of the regulators responsible for regulating for millions of individuals have a budget of a few £1 million, you know, maybe a staff of about 20. I mean, you know, not in any way equipped. Companies which I think, at least to some extent, hope the issue would simply go away and people wouldn't necessarily notice, in terms of the rigors of the law, what was going on. And I think that produced a very unfortunate result, because it resulted in, whereas the legal process should have been focused on, okay, we have these provisions, we need better enforcement, and maybe we need to pull back on some of the rules which don't make sense. Instead, we got a European reaction, which is that we need massively increased enforcement, which we'll see if it actually happens, actually. But we need yet more rules and yet more provisions, which takes us further and further and further away from other perspectives in other jurisdictions, in particular America. So because sort of both camps in a way haven't been very well talking to each other, we're moving in legal terms in many ways further away from one another. And obviously it's an imperative for legal development that is reversed, but it's very difficult. We now will have, maybe the UK won't because we might be leaving the EU, but the EU regulation is coming in 2018, and based on past practice, it will be the law for 20 years. You know, that's the kind of lifespan. So we're sort of stuck where we are. We can move around the edges, but we're sort of stuck where we are, and I would like to be in a different place.
On that note, thank you very much, David.
Not a different place as in being in Hong Kong. But
Thank you very much, Dr. Erdos and Mr. Marwah. May I ask you to join with me in expressing our appreciation for the chair and the speaker this evening. On behalf of the organizers, we also very much would like to thank you as members of the audience for your patience and for your participation this evening. And it remains for me to say good night and to well, we can go back and celebrate or commiserate, as the case may be. Thank you very much again.